Let me continue by using the example of the use of a drone to kill Anwar al-Awlaki. The case posed two issues mixing law and fact. First, did al-Awlaki pose an imminent threat to the United States? Here, much turns on the definition of imminence. I don't want to go into the details. For present purposes, we can describe the agency's actions as interpretations of law, which, under administrative law principles, the courts would have to accept if they were reasonable. The court would almost certainly find that they are, referring to the expertise of the agencies in matters of counterterrorism policy. Second, were alternative means of thwarting the threat, such as capture and arrest, reasonably available. Treating this as a determination as an ordinary matter of administrative law. With respect to the legal components, courts would defer substantially to the agency's judgments. And with respect to the factual ones, courts would ask whether the conclusion that capture was infeasible was arbitrary or capricious in light of the facts presented to it. It's worth noting that in counterterrorism matters, the question of what record might be available to the courts is open to question because the agency might withhold information from the courts on national security grounds. Even so, I'm quite sure that judicial review of administrative targeting decisions would quite rarely and possibly never find the decisions legally unjustified. So under ordinary administrative law, courts would play a quite limited role after the event. Under counterterrorism policy, they might play no role at all, and yet the incremental value of judicial participation might well be quite small, given rules of deference as to the law and the facts that courts would surely apply anyway. What that means is that we would have to rely on the political constraints on agency action to ensure compliance with fundamental law. And that's the conclusion we would draw were we to think about the problem as one of emergency law. Now, one seeming difference between ordinary administrative law and national security activities is this. Ordinary administrative law gives Congress primacy in policymaking, subject only to whatever feeble controls the theory the unitary executive places on Congress's ability to select the personnel who gets to implement congressional policy. In contrast, presidents and their more enthusiastic supporters sometimes fairly claimed in extensive inherent power from the Article 2's take care and more significantly commander-in-chief clauses. Again, though, administrative law provides a framework for thinking about claims of inherent in presidential power as well. Now, ordinary administrative law rests on the proposition that administrative agencies are indirectly politically accountable to the legislature, that delegates authority to them, and that can restrict those delegations through specific statutes or expand them through general ones, and to the executive who appoints agency personnel. As a formal matter, of course, those features characterize the national security bureaucracy as well. The secrecy associated with counterterrorism policies bring into question the accountability to the legislature and through it accountability to the public. In the paper, I go through the mechanisms of formal accountability to Congress, legislation directing the agency to act in specified ways, control of the agency's budget, oversight hearings, without supplementation by informal mechanisms. In the United States, those formal methods can be quite weak with respect to counterterrorism agencies because of the secrecy associated with counterterrorism policy. Even when the broad contours of a policy are widely known, details are tightly held, and often for good reason. That, of course, makes it difficult for a legislator to use the accountability mechanisms. A legislator might well think it good to have a policy about using drones against terrorists, and yet be concerned about the precise conditions under which drones would be so used. The legislator might know that the U.S. does have a policy and might want to provide funds for it, but might not know what the policy was. Accountability through budgetary decisions is difficult under those conditions. Now, some of those problems have been addressed in the U.S. through a program of disclosures to a small group of legislators who hold specific positions on relevant committees. But reports suggest that these legislators are regularly dissatisfied with the quality of the information they receive. Sometimes they know or think they know that information has been withheld from them. More important, perhaps, sometimes they don't know what they don't know. Former Secretary of Defense Donald Rumsfeld's unknown unknowns. The formal mechanisms of accountability simply can't work in such circumstances. But there are also informal mechanisms that do promote accountability. Jack Goldsmith has suggested several. I want to talk about two: bureaucratic resistance generated by concerns about departures from professional norms and leaks from within the counterterrorism bureaucracy. In the U.S., counterterrorism policy is made not in a single bureaucracy tasked with that subject, but it's made by a number of agencies which have other responsibilities. They take part in making counterterrorism policy. Lawyers in the Department of State and divisions of the Department of Justice, other than the one focused on counterterrorism, in the General Counsel's offices, in the military branches, all have occasion to weigh in on proposed counterterrorism policies. As legal professionals, they bring a perspective different from that of counterterrorism policy professionals. And as professionals in other bureaucracies, they're socialized into bringing their department's perspectives into the discussion. So a counterterrorism expert might be less sensitive to some aspects of the foreign policy implications of a proposed policy than someone from the Department of State, and a non-lawyer counterterrorism specialist might well be less sensitive to legal and constitutional constraints on policy than any lawyer would be. As counterterrorism policy develops, it's shaped by these various professional concerns. In particular, professionals not primarily associated with counterterrorism will sometimes push back against counterterrorism experts out of concern for compliance with the norms of their own professions. And accountability to professional norms has some connection to public accountability. A stronger connection occurs, of course, when someone leaks information about counterterrorism policy to the press. The press and legislators then can use that information as the basis for pursuing additional questions about the policies. Now, of course, makers of counterterrorism policy don't like leaks, and they do what they can to suppress them, but complete suppression is impossible. And I suspect that the more problematic policy, the more likely the leak. Now, the accountability effects of leaks occur erratically and gradually, and many policies will have been implemented, many drone strikes carried out, before accountability via leaks and legislative follow-ups occurs. But against the weaknesses of actual leaks as an accountability mechanism, Goldsmith emphasizes that the mere possibility that something will be leaked constrains policymakers. They always ask themselves, what will happen after this is in the headlines of major newspapers? And that's how all accountability mechanisms should work, guiding decisions as they are made and only secondarily imposing consequences afterwards. So now, bureaucracies are porous, leaks are inevitable, but they're not systematic or comprehensive. And the final question I want to address is whether a vigorous judicial role might improve on political accountability. Proponents of such a role say it's available with respect to every claimed constitutional violation in connection with counterterrorism policy, and they say it provides a timely response, exposing counterterrorism policy to evaluation in almost real time and sometimes even before action is taken. Now, I think those advantages are quite overstated as they're generally put. The reason is a combination of justiciability doctrines in the United States and prerogative powers, doctrine about prerogative powers elsewhere, that prevent courts from considering the merits of constitutional challenges. Standing is difficult to satisfy in the United States. Timeliness is not guaranteed because litigation takes time. The defendants can delay by refusing to disclose information until until the information is widely it must be made available. And so I believe that in most cases, the courts are not going to be able to do very much in the way of timely intervention or even post-event intervention. Now, you might say, okay, that's about particular events. What about the policies themselves? Here too, at least in the United States, the courts aren't in a position to give prior approval to policies in the abstract because of doctrines, including ripeness and standing, that obstruct those actions. Now, there's one important qualification about courts. NGOs can use judicial proceedings as a vehicle for mounting public campaigns for accountability. Here, the mechanism is not accountability by means of actions by the courts, but rather accountability by means of actions in court. The NGOs might be unable to attract substantial public attention to the issues that it's concerned with in the absence of a court proceeding. Mainstream media will report about court cases, but might not report about a press conference denouncing the way counterterrorism policy has harmed an individual or family. Now, if one's willing to treat leaks as a mechanism for promoting accountability, I think one, that is me, I have to treat this almost accidental characteristic of courts as another mechanism, and it counts in favor of judicial action. But my conclusion is that political accountability in the domain of counterterrorism policy is likely to reach about as high a level as accountability as we're likely to get. That level might not be high, but adding judicial review to the process isn't likely to provide a significant increment of accountability. I'm not arguing that existing administrative law deals with national security matters no less than it does with food safety. Rather, my suggestion is that administrative law provides the conceptual resources, both doctrinally through Chevron-like ideas and theoretically through this combination of concern for expertise and political accountability, that we could use to think about fitting war as a condition into our general constitutional framework. War is not a state of exception in constitutional terms. It's a rather banal domain in which administrative law could serve us as well as any version of emergency law could. Thank you.